We are going to live court in the state of Idaho versus Bryan Kohberger. The reason we are going to live court in the afternoon is because this hearing started in the morning and was sealed to the public, meaning no public at all. So we were waiting for the public portion of the hearing. There was a hearing that was emergency docketed yesterday on January 22nd, where a media coalition, through their attorney, the same attorney who's in the Idaho TikTok psychic defamation case representing the professor, same attorney, was in court, via Zoom, yesterday arguing that the public has the right to access all of these hearings. At the end of the day, the court said, yeah, no. So the hearings this morning were hearings with witnesses. And by this morning, I mean most of the day, local time, mountain time, before and after the lunch break. So they had multiple, I assume, witnesses testify. I would love to tell you what the witness list looks like and who testified, but it's also sealed. So the hearings today are regarding motions to suppress. What does that mean? It means the defense has made their motions to suppress a whole bunch of evidence before this goes to trial, including evidence gathered from Bryan Kohberger's apartment, his Amazon account, his Apple accounts, anything taken in a search with the arrest warrant, anything from AT&T, all of his cell phone data, pen trap and trace data, search of his person in Idaho, anything from the search of his person in Pennsylvania, anything searched from the white Honda, things searched from a home in Pennsylvania, his Google accounts, and more. So they are trying to say, Your Honor, for reasons, and we're going to hear those today, for reasons, you need to suppress whatever law enforcement got from this particular search warrant, or thing. What we're not going to hear is what happened with the investigative or the IgG DNA. That was the sealed portion of the hearing. The court has said that is all going to remain sealed, that information could potentially taint a future jury, and it might not come in at trial. And by might not, it's not coming in at trial. The IgG DNA will not be a part of the trial. That is part of the investigation. It's like step one to how they get to other things, but it is not going to be evidence in trial. So the court has sealed all of that while they are going through those hearings. At the end of the public portion of the hearings today in Idaho for the Idaho versus Bryan Kohberger case, we ended with arguments over whether or not there would be a Franks hearing. The defense is asking the court to decide if there will be further evidentiary hearings regarding whether or not there were material misstatements or omissions in the affidavits that led to the search warrants. That is the request for the hearing. Tomorrow, we will be resuming with evidence in the motions to suppress multiple different items of evidence. There are so many hearings ongoing because the court set very specific dates in this case, meaning all of these evidence hearings are going to be heard at the same time. A, it's judicially efficient. B, it keeps filings from trickling in. And C, the attorneys get to make all their arguments, reply to all the arguments, and then it's settled. These are items that need to be settled in advance because at the end of the day, the defense is trying to suppress as much as they can. That is their job. If there were errors in the process, then we will see if that all gets suppressed or not. The court indicated in arguments that he is maybe not super persuaded with regard to whether the DNA that was the subject to the closed hearing this morning will get suppressed. The court is curious about whether or not Bryan Kohberger has the right to argue about how investigators recover evidence from the crime scene, test evidence from the crime scene, run it against DNA databases that don't include his DNA, that he had not submitted his DNA to. And the court asked repeatedly, what is defendant Bryan Kohberger's right to privacy or expectation to privacy in DNA databases that he's not put his DNA into, or in DNA at a crime scene at all before it's identified as his. And they're not arguing, well, he left his thing in this place that he doesn't have a reasonable expectation of privacy in, because of course they're arguing that he was not in the house where the crimes took place. So we will see what happens with these hearings. The court has taken them under submission. This court has been fairly quick with turning around very thoughtful rulings. So we will see what Judge H does. I think that with the IGG, or the Investigative Genetic Genealogy, DNA, that the court is not ultimately going to be persuaded. And the court, it doesn't seem, is particularly persuaded one way or the other yet with the affidavits on the search warrant, and asked the defense repeatedly, but if there is DNA, isn't that enough to get us to probable cause? If we have DNA on a knife sheath where there are victims who have been stabbed, and that DNA tracks back to the defendant, isn't that enough for a judge or magistrate to find probable cause for search warrant affidavits? And it seems that that has been the consistent question throughout all of the arguments today. So will there be a Franks hearing? We will see what the judge rules. Unlikely, probably at this point. Will the IgG DNA be suppressed? Also unlikely at this point. And then we get into all the motions tomorrow. So over the last 2 days, January 23rd and January 24th, there have been hearings in Idaho that some were sealed, some were public. The defense is arguing all of their motions to suppress and a motion asking for a Franks hearing, as well as requests for discovery. With regard to the sealed portion of the hearing, that was regarding investigative or IgG DNA, that was largely sealed, but the arguments were public, and that's where we picked up on January 23rd, Thursday. Then getting into Friday, we got into the rest of the motions for suppression. The defense is asking essentially to suppress all of the evidence that came from 14 different search warrants, arguing largely that either the search warrants were overbroad and not particularized enough, or that the search warrants were so deeply based on that investigative or IgG DNA that when that IgG DNA gets thrown out, that the rest of the search warrants should get thrown out. And then, of course, the argument that there needs to be a separate hearing with evidence regarding the search warrant affidavits, that Franks hearing. The court has indicated that they do not know if that hearing will be granted, and that they will be issuing orders forthwith, which means really as soon as practicable for the court on all of these motions. Remember, it was over 14 motions. So the court is probably going to lump together most of the motions to suppress, then the Franks motion, the IgG motion separately, and then on the discovery motion, the defense was asking about the state expert disclosures, saying that the state had not fully disclosed enough the opinions of their experts, the reports of their experts, and what additional information there will be. And the court strongly warned the state that the expert disclosure work was not done, and those expert disclosures needed to be supplemented so that the opinions of the experts were more fulsomely laid out in the expert disclosure. And the court made clear that what they expect is a substantial amount of information in the disclosure, not just bullet points. If it is a witness who is a crime scene tech that's explaining what DNA is, the court expects that that witness disclose how they will be explaining what DNA is. And that is the example that the court gave. This case still has a lot of litigation to go before it starts trial. The court warned the parties that he did not want to be stopping and sending the jury in and out so that they would have to find where these disclosures are. We know that just in these motions hearings, the defense submitted over 1,000 pages of supplemental material to the court. We know from arguments today that there are over 60 devices in this case, and that is not just devices from the defendant, but these are all kinds of devices. That could include things from the defendant's apartment, personal devices to witnesses, to victims, to others. This could also include security cameras and things like that. So over 60 devices in this case that will need to be looked at. And the defense said their expert indicated it would take over 3 years to look at all the data from just those devices. And we know there's more data than that in this case. There's over 50 terabytes of data. There is lots more to come. This judge has been thoughtful in their rulings. I'm interested to see how they break it down. For now, some of the defense arguments are preserving this case for appeal. Do I expect this level of motion work in a case this serious? Absolutely. And we've seen that from the defense. These attorneys are incredibly swamped with the amount of work they have to do to get this case ready for trial. And it seems that all sides are A, doing that, and B, also tired. So it's going to be a very busy and long road to get to that trial in August, but also for the attorneys between now and then, there's just not going to be enough time to do everything that needs to get done because there is so much volume here. And for the prosecution, it seems that one of the problems is going to be that so many chefs were in the kitchen in this investigation. Trying to parse out who did what part of what looks like it is going to be at least somewhat difficult to parse in a way that is in order. Oftentimes we will see one or two officers come in and they know everything that happened in an investigation. Here, there are multiple officers in charge of different parts of this investigation from multiple different agencies, and that can make it a little clunkier when it gets to trial. But this is going to be a long trial. What I do trust from Judge H is that this trial will move as smoothly as humanly possible based on the work that he has also put in leading up to this case. So it's nice to see the attorneys working together better than we've seen in the past. We have not seen any of the courtroom devolving into the more salacious language that we have seen in the past. We have not seen the attorneys making accusations to one another. We have not seen Prosecutor Santa lose his cool again after being feisty with an expert about whether or not he held a press conference. We've seen these attorneys really settle down into this case with a judge who is not here for that level of hyperbole. I'm waiting for this judge at some point to say that level of hyperbole is not helpful. Look, those of us that love the drama, and occasionally who doesn't love the drama, in a criminal case this serious, we're not really going to see that level of courtroom theatrics. I appreciate that the judge has really toned that down. And I think when this goes to trial, we will see that continue because of this judge's no-nonsense demeanor. He really did take charge of this trial and say, all right, children, what we're going to do is get this trial done. What we're not going to do is sit here and fight back and forth with each other and yell back and forth at one another and huff and puff. Though we see a lot of that in civil, this judge is not having that in this criminal case. And I think in the cases that I'm covering, we're going to see some civil judges get real feisty real quick in some of the cases. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.